Good morning, or I should say perhaps also good afternoon or good evening to all of you, because we know that we have thousands of attendees registered for this conference, pretty much from everywhere in the world. And I have been receiving messages over the past few days from people from Australia, Latin America, and any number of countries to tell me that they would be joining us today. So good morning, good afternoon, or good evening. And particularly thank you for those who are awake in the middle of the night to listen and watch this event. Now, I have few very pleasant tasks this morning, essentially to introduce the conference and to open the conference on behalf of King's College London. But first of all, the most difficult task, which is to introduce myself for the very few lucky of you who do not know me. My name is Renato Nazzini. I'm a professor of construction law and arbitration at King's, director of research at the Center of Construction Law and Dispute Resolution. And I also practice as an arbitrator and counsel in international arbitration, as many of my colleagues at the Center of Construction Law. So let me say, I think, just a few words as I explain by way of introduction. I think just five things I'd like to say. First of all, this conference is co-organized and co-hosted by the Center of Construction Law and Dispute Resolution at King's and the Academy of Experts. The Center of Construction Law, as many of you know, not least because I have seen hundreds of our students and alumni register for this conference, and some of them also speaking at the conference, of course. So the center, as you know, was established 33 years ago at King's here in London, just a stone throw from the courts, the technology and construction courts. And since the very beginning, we have been discussing, learning, developing construction law in the UK, internationally, in an interdisciplinary way. And we have been working in the past with the courts on mediation and ADR here in London. We have been working with arbitral institutions around the world to develop construction arbitration. And our research on contractual models is now being applied in construction projects worth billions of dollars around the world and in various continents. I have mentioned already the MSc, which we run every year. We welcome between 50 and 70 students, very rigorously selected. And it's great to know that many of them are here with us today, taking time off their busy schedules as arbitrators, experts, project managers, engineers, architects, surveyors, to be with us. I extend to all of them a very warm welcome. Of course, as I said, this conference is being co-organized with the Academy of Experts. It's a great pleasure for us to team up with them. The aims of the Academy and those of the Center in different ways are, however, very much aligned. We are also contemporaries. The Academy of Experts was established just over 30 years ago, pretty much the same time as the Center of Construction Law. And since it has become an international center of excellence for experts, recognized as both an accrediting and a professional body, the Academy actively promotes the use of cost-efficient dispute resolution, so pretty much the same as the center, and it's a great pleasure for us, as I said, to be organizing this event with them. Third, of course, I would like to thank all the chairs, the speakers, and the attendees at this conference. Any conference is really only as good as you are. There is only as much the organizers can do. I'll say a little bit more about it in a moment. But of course, it's the quality of those who participate as speakers, chairs, and from the audience that makes a great conference. And as I was going through the program again just this morning and the list of attendees, I came to the very firm conclusion that only one thing can go wrong in this conference. if the UK IT infrastructure is subject to a massive cyber attack. Other than that, I have no doubt at all that this is going to be a fantastic, challenging, interesting day of debate and ideas. And of course, on behalf of King's, on behalf of the Academy, and on behalf of all of you, I am particularly grateful to Dame Finola O'Farrell, the judge in charge of the Technology and Construction Court, for being with us today and agreeing to give the keynote speech. The TCC is, of course, the jewel in the crown of the judicial system here as far as construction law is concerned. As an arbitration lawyer, I'm particularly, in a way, sorry to say that very often parties prefer the TCC to arbitration. As good the TCC it is, and we look forward to hear from Dame Finola on the recent experience of the TCC in resolving and managing construction disputes so well. My fourth point is also very important, and is to thank the Center of Construction Law at King's staff, who you will not be seeing today, but who behind the scenes have worked extremely hard to make this conference run smoothly. Graham Stephen, Brian Davis, Madeleine Ryan, Susan Hart, and many other colleagues. I think any of us who have been working on virtual hearings know very well what it requires to run an online event, which a hearing in a sense is, in many ways the same as a conference. First test run, a second test run, and then checking the IT connection in the room where the witness is, and the camera and the second camera, and so on and so forth, and how you have to be very attentive to any detail for the event to run smoothly. And that's what our colleagues have done, and I'm very, very grateful to them. I have just one last point. I promised everybody that I wouldn't abuse my position as giving the opening address in this conference. And this is to thank and introduce James Pickavance, a driving force behind the organization of this event, of course, together with all the other law firms and the institutions who have participated and are represented on our excellent panels. James is a partner at Jones Day in the firm's Global Dispute Resolution Group, and he heads the international construction dispute resolution practice here in London. He represents contractors, owners, developers, consultants in public and private projects, and has wide experience in the UK and abroad. But many of you know that. Much more importantly, I would say, James teaches with me and with us on the MSc, and is very active at the Center of Construction Law and Dispute Resolution. And the reason is that a few years ago now, I came across this new and extremely interesting book on construction adjudication by James. And I read it, and before he knew it, James was asked and persuaded quite effectively, I think, because in the end he said yes, and he's been contributing significantly to the center to join us on the MSc. So I end with a word of warning, perhaps, to all of you. Before you think about writing a very good book on construction law, think twice, because before you know it, you may find that you are co-opted by us to work with us on our research projects, on our practical engagements, on our MSc, and we can be, as James can witness, very, very effective in our persuasion. But James, I hand over to you as chair of the conference. Thanks very much again, and I wish you all a very successful conference, and thanks very much again. Thank you.
Professor Nazzini, thank you. As of this morning, we have just under 3,500 people from 24 countries registered for this event. And to give you some perspective, that number would more or less fill the Royal Albert Hall, which is quite remarkable when one considers that those of us based in London usually pedal along to events with a capacity of a few hundred at most. To my mind, that's a result of three things. Firstly, and probably most obviously, the accessibility and, dare I say, the affordability of online presentations. Second, the extraordinary pool of talent that we have in London and indeed across England and Wales. Perhaps for the first time, this conference unites those global law firms, chambers and expert consultants who have a base in London and who specialise in international construction dispute resolution. All those people that you'll hear from today, many of whom I've acted with or against, are truly world-class private practice and in-house construction disputes lawyers. They are an international construction think tank of men and women, but are really only a small fraction of the army of legal souls based in London, be they lawyers, experts or consultants whose full-time focus is construction disputes. And the scale of the operation that exists here is, to my mind, unequivocally the largest anywhere in the world by some margin. And finally, the topics, which are as varied as they are fascinating, all in the context of construction disputes. The speakers will deal with technology, termination, avoiding disputes boards, witnesses, documents, how to get arbitration right, and finally, what does the paying client think about it all? Just a few administrative matters. Each session is 40 minutes. You have the schedule in your emails, and I think a link has been posted on your screen, and we'll do our best to run strictly to that, not least so that you can dip in and out as we expect you will. Questions, please ask them. All the sessions really encourage it. It will make this more engaging. There's a questions button on your screen. Type your question, and unless it's technical or rude, it'll appear to the panel and all the other delegates. There is a like button next to the question. If you like a question that somebody's asked, click the button and like it as you would a social media post. And the more likes a question gets, the more likely the panel chair or I will put it to the panel either during the discussion or at the end. So let's move to our first session today, and indeed our keynote speech entitled International Construction Dispute Resolution in London. I am pleased and honoured in equal measure that this session will be given by Mrs. Justice Finola O'Farrell DBE QC. Finola is, as Renato said, judge in charge of the Technology and Construction Courts, a specialist group of courts dealing with disputes in those sectors based in London and at centres across England and Wales. Finola was called to the bar in 1983 by Inner Temple and took silk in 2002. She was appointed as a recorder in 2007 and made Justice of the High Court in 2016, assigned to the Technology and Construction Courts, now of course part of the Business and Property Courts. Prior to her judicial appointment, Mrs. Justice O'Farrell had over 30 years experience as a leading barrister in construction, engineering, energy, shipbuilding and information technology cases. She acted regularly as counsel or arbitrator in international arbitrations and is an accredited adjudicator and mediator. I can scarcely think of anybody better qualified to tell us about international construction disputes in London than our speaker. Finola, over to you.
Thank you, James. Good morning and good afternoon and good evening to everyone. The Business and Property Courts of England and Wales were introduced in 2017, so just over 3 years ago, known as the BPC. They were created as a single umbrella for specialist jurisdictions across England and Wales. And in London, they are based in the Rolls Building. They comprise the Commercial Court, including Admiralty, the Chancery Division, and then the Technology and Construction Court, TCC. The BPC at the Rolls Building is the largest specialist centre for financial, business and property litigation in the world. The TCC deals with cases involving technical complexity, as I'm sure many of you already know, It specialises in construction, engineering, energy, IT, procurement, and other technical disputes. One of the main features of the TCC is that it uses proactive case management to ensure that when a case is started, the assigned judge ensures that there is a timetable in place so that all of the preparatory steps are taken at the appropriate time, so that the disputes can be resolved speedily and with proportionate cost being incurred. During this conference, you're going to hear about various methods of resolving disputes or avoiding disputes using perhaps informal or alternative forms of dispute resolution process. I welcome any steps that the parties can take to avoid or resolve their disputes without having to resort to litigation. However, sometimes it is necessary to obtain a final third-party determination, either by litigation or arbitration. Litigation, of course, is a public adversarial process whereby a binding third-party decision is obtained to enforce rights and remedies. It's appropriate in cases such as the following. For example, cases that require a determination on a difficult point of law so that it can be used as a test case. Multi-party disputes where there aren't provisions for arbitration between more than two parties, or where there are jurisdictional issues, cross-border disputes, and other such complicating factors that make other forms of dispute resolution difficult. Cases that perhaps involve very substantial issues of expert evidence and fact, or where, for example, there are allegations of fraud or dishonesty that require a public forum for determination. And others, for example, where the final remedy is an injunction and perhaps where the parties need to freeze assets. And then, of course, finally, the court is often used to enforce the results of other forms of dispute resolution, such as adjudication, expert determination, and arbitration awards. In terms of arbitration, the court's role is very much one of supervision, light supervision, and support. Arbitration may well be chosen by parties where they require privacy and confidentiality, where they want to retain control over the process. But regardless of that, the parties still need to know that there is some means of enforcing their award once they've obtained it. The overriding philosophy of the Arbitration Act 1996, which is the guiding provision, is one of party autonomy, so that the court will have a minimal intervention role in supervising the arbitration, and also the principle of finality of awards, so that the courts will engage in swift enforcement procedures, and there are limited grounds for review of the awards or the arbitral process. The courts will intervene in certain appropriate cases. So, for example, during the course of an arbitration, it may be that the court would remove an arbitrator. That's provided for under Section 24 of the Act, in cases where it might be thought that there was a risk of either real or apparent bias. That is, if there are circumstances that would lead a fair-minded and informed observer to conclude that there was a real possibility of bias, i.e. that the tribunal member might not be impartial. More often, the court is called upon to deal with issues that arise on enforcement. That is usually under Section 66 of the Act for domestic arbitrations and Section 101 of the Act for New York Convention arbitrations. And those provide that the courts will, in respect of an award made by a tribunal pursuant to a valid arbitration agreement, will enforce the award in the same manner as a judgment or order of the court to same effect. That is usually done by an application made on paper, or these days electronically, to the court. The court will then give the respondent 14 days to raise any objection to enforcement, following which the claimant in the proceedings is entitled to judgment in respect of the award. The court does have a very wide and unfettered discretion to adjourn a decision on enforcement where there's an outstanding challenge to the validity of the arbitration award in the country where the award was made. Other than that, the grounds for challenge are fairly limited, essentially under sections 67, 68 and 69 of the Arbitration Act. A party may wish to challenge the substantive jurisdiction of the arbitral tribunal. A party may want to raise an issue of procedural irregularity, that is, to argue that the tribunal did not determine the dispute in a fair and impartial manner. But the courts will only interfere with the substance of the arbitration award and refuse to enforce it or set it aside in very, very limited circumstances. And the courts have to be satisfied that any irregularity that is identified is one that causes serious, substantial injustice to the applicant. It is very rare for the court to find serious procedural irregularity. The court has to be satisfied that the tribunal has gone so far wrong that it calls out for some form of corrective action on the part of the courts. There is a very recent example of such a case. I think last week, a decision was handed down in the Federal Republic of Nigeria and Process and Industrial Developments Limited. For those who want to look at it, the citation is 2020 EWHC 2379 commercial cases. And in that case, the court granted a substantial extension of time to allow the claimant in the case to challenge, to make challenges to the arbitration award on grounds of fraud. The court was satisfied in that case, which arose out of a gas processing contract, that although the arbitration had been started in 2012 and the final award had been published in 2017, that there was a strong prima facie case made out, that is on the documents and the submissions made by counsel, that the contract or the awards had been procured as a result of fraud. And I have to say, rather surprisingly, one of the allegations is that one of the counsel in the case deliberately lost the case, almost unheard of, but clearly very serious allegations that have to be investigated. But it is, I have to emphasize, a very, very rare set of circumstances indeed. And then finally, the court can grant permission to appeal on a point of law under Section 69. Again, it is very rare for permission to be granted or for the appeal to succeed, because it is only granted where the decision of the tribunal on the law, not on the facts, is obviously wrong, or the question is one of public importance, and the decision is at least open to serious doubt. Other than that, the court will generally act in a role to support and enforce the outcome of arbitrations. Before I finish, I just want to say a few words about remote hearings. All around the world, everyone has been affected in some way by the COVID-19 pandemic, and the courts have not been immune to the impact. On the 23rd of March 2020, in the UK, lockdown was announced. On that day, the TCC issued template orders and draft letters to be sent to all the parties for remote hearings. We were already, in fact, hearing some applications remotely. Within a few days, there was a protocol in place for remote hearings for use across all jurisdictions of the High Court. In the TCC, a small number of trials were adjourned for COVID-19 reasons. In one case, because the party's facility was in Lombardy, right in the middle of the Italian lockdown, and the experts couldn't get access to inspect, and no one could get any documents out. There were a few others where parties and witnesses just weren't ready to switch to a remote trial, and therefore it was appropriate to adjourn it. Generally, those cases have either been heard during the vacation, and I'm hearing one next week, or alternatively they have been relisted for early 2021. Other than that, all hearings went ahead as originally listed, save that the hearings were remote, usually by video link. In the first 6 months of this year, new cases in the TCC have increased by some 6%, and that is on top of the overall increase the previous year of 20%. Since the beginning of July, the courts in London have been offering the parties full physical hearings in court or hybrid hearings where it's appropriate and the parties wish to have a physical hearing. I have been very impressed by the cooperation and flexibility shown by the parties, by their legal representatives, by the experts, and by the court staff to ensure that the wheels of justice could keep turning. I think we have benefited from learning how to use technology, for example, this conference, to improve the efficiency and cost of legal proceedings in general without compromising justice. We do recognise the value of continued physical hearings and physical meetings where appropriate, but I think that this has served to demonstrate the resilience and the agility of the courts in England and Wales generally, and in London in particular. And so I just conclude by saying that the courts in London, and in particular the TCC, are ready to welcome parties from all over the world to resolve their disputes. Thank you.
Finola, thank you very much for that erudite whistle-stop tour of TCC's function. We have time for just one question that has come in from an anonymous participant. The question's as follows. Do you believe that the barrier to gaining permission to appeal under Section 69 of the Arbitration Act is too high? Would something more akin to the test for summary judgment be more appropriate, particularly given that Section 69 is optional and that parties can exclude it?
I think the balance is about right. I don't think that we should move to a summary judgment test. If I were a disgruntled party following an arbitration, I'm sure I would take a different view. And in the past, I probably have taken a different view. But the reason I don't think it's appropriate is because the whole philosophy behind the Arbitration Act 1996 and the court's approach to arbitration is one of light supervision and support, not interference. The difficulty with a summary judgment test, which would be to consider effectively whether there was a real prospect of the appeal succeeding and not looking at anything else, is that it would be very much a review of what the arbitrators had done. Instead, the court's approach is to only step in and allow permission to appeal if it's satisfied that this is a case where something clearly has gone wrong. I think that's about the right balance, because the point behind it is that the parties have agreed that they're going to resolve their disputes by arbitration. And what is most important to commercial companies where they have a dispute is that they have finality. And I think that that overrides the need for the disappointed party to have a go at overturning an otherwise valid award.
Very good. Finola, I think we are out of time. Thank you very much for spending time with us this morning. We're all very grateful for your input away from the courts. Thank you very much.